जय हिंद दोस्तों, फिर से आपका स्वागत है हमारे इस यूट्यूब चैनल ज्योग्राफी फॉर यू में। और इसमें हम लोग का जो इतने देर से वेट कर रहे थे विजन आईएएस का PT 365 पॉलिटी, वो आ चुका है, जो अप्रैल 2023 से लेकर दिसंबर 2023 तक का पूरा कंपाइलेशन है। और इसे अब हम लोग करने वाले हैं, तो बस आप लोग हमारे साथ बने रहिए और हम लोग पूरा का पूरा ये कंपाइलेशन करने वाले हैं। तो आइए शुरू करते हैं टॉपिक 1 से, जिसमें इशूज़ रिलेटेड टू द कॉन्स्टिट्यूशन। तो यहाँ से शुरू करने वाले हैं और हम लोग यह पूरा का पूरा बुक खत्म करने वाले, जितना भी इसमें इशूज़ जो भी टॉपिक्स दिए हुए यहाँ 8.8 तक। तो बस आप लोग हमारे साथ बने रहें और देखते रहें कि हम लोग कैसे इसे कंप्लीट करते हैं। आपसे बस ये अनुरोध है कि अगर आप लोग हमारे चैनल पर नए हैं और अभी तक हमारे चैनल को सब्सक्राइब नहीं किया तो प्लीज़ इसे सब्सक्राइब करें, वीडियो को ज़्यादा से ज़्यादा शेयर करें उन लोगों तक जो विजन 365 PT पढ़ना चाह रहे थे या उन्हें इस चीज़ की डिमांड थी, तो उन तक इस वीडियो को जरूर पहुंचा ताकि उनका रिवीजन अच्छे से हो सके। और इसे हम पूरा कंप्लीट करने वाले। इसे क्या मतलब, आने वाले जितने भी PT 365 होंगे, पॉलिटी हो गया, इकोनॉमिक्स हो गया, हिस्ट्री हो गया, आर्ट एंड कल्चर हो गया, इन्वायरमेंट इकोलॉजी हो गया, तो सारे कंप्लीट करने वाले। तो बस हमारे साथ चैनल में बने रहें। और अगर आप लोगों ने वाजीराम एंड रवि का करंट अफेयर वाला सीरीज़ नहीं देखा तो वो भी देख ले, वो भी हम लोगों ने अपलोड किया हुआ है और उसमें भी रेगुलर वीडियो जा रहा है करंट अफेयर का, तो उसे भी आप लोग देखें। तो आइए शुरू करते हैं। पहला है इशूज रिलेटेड टू द कॉन्स्टिट्यूशन। उसमें पहला है बेसिक स्ट्रक्चर डॉक्ट्रिन। तो वाई इन द न्यूज़ द लैंडमार्क केशवानंद भारती जजमेंट 1973 विच प्रोपाउंडेड द बेसिक स्ट्रक्चर डॉक्ट्रिन कंप्लीटेड 50 ईयर्स। तो इसके 50 साल पूरे हो गए थे। अबाउट द केशवानंद भारती केस 1973, इट डेल्ट विथ ए पिटिशन अगेंस्ट द कंपल्सरी एक्विजिशन ऑफ लैंड बाई द केरला गवर्नमेंट अंडर द केरला लैंड रिफॉर्म एक्ट 1963 as a violation of fundamental rights FRs under Article 25, 26 and 31 of the Constitution. The case was headed by the largest ever bench, that is 13 judge bench of the Supreme Court. Key outcomes क्या था? तो introduction of basic structure doctrine, upholding the validity of 24th constitutional amendment. The Supreme Court held that Parliament has the power to amend any or all provisions of the Constitution, including fundamental rights. However, such amendments should not alter, damage, or destroy the essential features of the basic structure of the Constitution. Earlier, in Gokhlanand case 1967, the Supreme Court held that the power to amend the Constitution under Article 368 was not unlimited and that the fundamental rights guaranteed under the Constitution could not be abrogated or abrogated by the constitutional amendment. Power of judicial review क्या हो रहा है इसमें, तो देखते हैं। The court held that the power of judicial review is an integral part of the basic structure of the constitution. Other judgment में क्या आया, तो Supreme Court upheld the 25th and 29th constitutional amendment except for the parts that curtailed its power of judicial review and asserts that the preamble is a part of the constitution and hence amendable. About basic structure doctrine क्या है, तो उसके बारे में देख लेते हैं। It holds that certain fundamental features of the constitution cannot be amended or abrogated by the parliament. There is no mention of the term basic structure anywhere in the constitution of India. Significance of doctrine क्या है, तो check on the power of parliament to amend the constitution, ensure that the constitution remains a living document that is responsible to changing time while preserving its fundamental values and principles. Lay down several principles that have become the bedrock of constitutional law in India, such as the rule of law, separation of power, and the independence of the judiciary. Ensures that the federal structure of the constitution is not undermined. Shapes the judiciary approach, the constitutional interpretation. बॉक्स में देख लेते क्या है, तो इवोल्यूशन ऑफ डॉक्ट्रिन ऑफ बेसिक स्ट्रक्चर कैसे कैसे इवॉल्व हो उसके बारे में है। तो पहला AK गोपालन केस 1973, ठीक है। फिर है शंकरी प्रसाद केस 1951, फिर है 1965 में सज्जन सिंह केस, फिर 1967 गोलकनाथ केस और 1971 केशवानंद केस, ठीक है। तो पहले देख लेते हैं AK गोपालन केस, फिर शंकरी प्रसाद केस और सज्जन सिंह केस में पार्लियामेंट कैन अमेंड एनी पार्ट ऑफ द कॉन्स्टिट्यूशन, ये था। फिर गोलकनाथ केस में क्या हुआ, तो आर्टिकल 368 डिड नॉट कन्फर एनी अमेंडिंग पावर टू पार्लियामेंट था। फिर फंडामेंटल राइट कैन नॉट बी अमेंडेड बाय पार्लियामेंट, ये हुआ। फिर 1971 में हुआ क्या, तो फंडामेंटल राइट्स ऑफ सिटीजन आर लिमिटेड, पार्लियामेंट कैन अमेंड एनी पार्ट ऑफ द कॉन्स्टिट्यूशन। और इसमें देखें तो 24th और 25th कॉन्स्टिट्यूशनल अमेंडमेंट क्या हुआ, तो कॉन्स्टिट्यूशनल अमेंडमेंट इज नॉट लॉ अंडर आर्टिकल 13, सो पार्लियामेंट कैन अमेंड इट। तो ये पास हो गया कि पार्लियामेंट उसे अमेंड कर सकता है। और दूसरा क्या था 25th में, तो सेक्शन 2 कर्टेल्ड राइट टू प्रॉपर्टी विथ ड्यू कंपनसेशन एंड सेक्शन 3 प्रोसीडेंस ऑफ DPSP ओवर फंडामेंटल राइट्स, तो DPSP को ज़्यादा प्राथमिकता दी गई फंडामेंटल राइट्स पे। टुक अवे स्पेस ऑफ जुडिशियल रिव्यू फ्रॉम 39B एंड 39C, 39B और 39C से जुडिशियल रिव्यू को हटाया गया, और उसी में 1973 में कृष्ण भारती केस आया। अगला सम प्रिंसिपल्स दैट आर प्रेजेंटली पार्ट ऑफ द बेसिक स्ट्रक्चर, तो कुछ प्रिंसिपल कौन कौन से देख लेते हैं। पहला, सोवेरेनिटी ऑफ इंडिया। सेकंड, एसेंशियल फीचर्स ऑफ द इंडिविजुअल फ्रीडम सिक्योर्स to the citizen. Next is mandate to build a welfare state. Next, supremacy of the constitution. Next, republican and democratic form of government. Next, secular and federal character of the constitution. अगला है separation of power between the legislature, executive and judiciary. अगला unity and integrity of the nation. Next is power of judicial review and last is harmony and balance between fundamental right and DPSP. तो और भी बहुत सारे यहाँ पे कुछ दिया हुआ है, तो वो हम लोगों ने पढ़ लिया है। आवर नेक्स्ट टॉपिक, इंडिपेंडेंस ऑफ डिस्ट्रिक्ट जुडिशरी बेसिक स्ट्रक्चर। तो ये न्यूज़ में क्यों रहा, वाई इन द न्यूज़। तो सुप्रीम कोर्ट इन द ऑल इंडिया जजेस एसोसिएशन वर्सेस यूनियन ऑफ इंडिया केस स्टैंड दैट द डिस्ट्रिक्ट जुडिशरी इंडिपेंडेंस इज अ पार्ट ऑफ बेसिक स्ट्रक्चर। मोर इन द न्यूज़ में क्या था, इट ऑल्सो हाईलाइटेड अदर प्रिंसिपल्स। पहला जिसमें इंटीग्रेशन टू टर्म्स ऑफ पे, पेंशन एंड अदर सर्विस कंडीशन बिटवीन डिस्ट्रिक्ट जुडिशरी, हाई कोर्ट एंड सुप्रीम कोर्ट। Separation of power. Officers of the judiciary should be treated separately from staff of legislature and executive beings. Unified judiciary में क्या है, तो service condition of judges for similar posts are equivalent across states. District judiciary क्या है, तो district judge is the highest judiciary authority in the district. Organizational structure, jurisdiction and nomenclature or subordinate judiciary are laid down by states, hence that they differ slightly from a state to state, broadly 3 tiers below the high court. अपॉइंटमेंट कैसे होता है, तो पोस्टिंग एंड प्रमोशन ऑफ डिस्ट्रिक्ट जज आर मेड बाय द गवर्नर ऑफ द स्टेट इन कंसल्टेशन विद द हाई कोर्ट। लोअर जुडिशरी में यहाँ पर देखिए हाई कोर्ट होता है, उसके बाद फिर आता है डिस्ट्रिक्ट एंड सेशन जज कोर्ट। तो इसमें दो तरह का होता है, सिविल साइड और क्रिमिनल साइड। सिविल साइड में देखते हैं तो उसमें होता है सबऑर्डिनेट जज कोर्ट, फिर होता है मुंसिफ जज कोर्ट, और क्रिमिनल साइड में चीफ जुडिशियल मजिस्ट्रेट कोर्ट और जुडिशियल मजिस्ट्रेट कोर्ट। और नेक्स्ट टॉपिक इज एब्रोगेशन ऑफ आर्टिकल 370। तो भाई इन न्यूज़ में क्यों आया, ए कॉन्स्टिट्यूशनल बेंच ऑफ सुप्रीम कोर्ट रिसेंटली अपहोल्ड द वैलिडिटी ऑफ यूनियन गवर्नमेंट्स 2019 डिसीजन टू रिपेल द स्पेशल स्टेटस ऑफ जम्मू एंड कश्मीर JNK अंडर आर्टिकल 370 ऑफ द कॉन्स्टिट्यूशन। मोर ऑन द न्यूज़ में क्या है, तो ऑन August 5, 2019 द प्रेसिडेंट ऑफ इंडिया प्रोमोलगेटेड एन ऑर्डर कॉन्स्टिट्यूशन अपॉइंटमेंट टू जम्मू application to Jammu and Kashmir Order 2019, which stated that provision of Indian Constitution are applicable in the state. Parliament also enacted the Jammu and Kashmir Reorganization Act 2019, which bifurcated the state into 2 union territories. The petitioners have challenged the constitutionality of this action of the union. Judgment क्या आया इस पे, तो upholding the presidential proclamation of August 2019. The Supreme Court held that Jammu and Kashmir did not retain any element of sovereignty after it acceded to India in 1947. Supreme Court held that Article 370 is a temporary transitional provision. The court held that UT can be carved out of a state. Parliament may by law form a new state by separation of territory from any state or by uniting 2 or more states or part of a state by uniting any territory to a part of any state. According to explanation 1 to Article 3, the word state are used in Article 3 Clause A include a union territory. Relying on the judgment in SR Bommai case, Supreme Court held that actions of President during a state emergency were open to judicial scrutiny. Article 370 a historical context में क्या है देख लेते हैं। So, Instrument of Accession IOA in October 1947, Maharaja Hari Singh, the last ruler of Jammu and Kashmir, signed the IOA, through which he agreed to accede his state to the dominion of India. Temporary provision for Jammu and Kashmir क्या था, तो under the Constitution, Article 370 was placed in Part 21 titled Temporary and Transitional Provision. Article 370, except for defense, foreign affairs, finance and communications, Parliament needed the state government's concurrence to apply for all other laws. Article 35A of Indian Constitution, it streamlined out of Article 370 and gave power to Jammu and Kashmir Assembly to define permanent residents of the state their special rights and privileges. आर्टिकल 3 में क्या था, तो इट प्रोवाइड्स दैट पार्लियामेंट में बाय लॉ फॉर्म न्यू स्टेट्स एंड अल्टर of areas, boundary or names of existing states. First proviso of the article states that bill for above law shall be introduced in either house of parliament on the recommendation of president. If the bill affects the area, boundaries or name of any state, the president must refer the bill to the state legislature for its view. अगला टॉपिक है नेशनल कैपिटल टेरिटरी ऑफ दिल्ली अमेंडमेंट एक्ट 2023. तो न्यूज़ में क्यों रहा, रिसेंटली द गवर्नमेंट ऑफ नेशनल कैपिटल टेरिटरी ऑफ दिल्ली NCTD अमेंडमेंट एक्ट 2023 रिसीव्ड द एसेंट ऑफ द प्रेसिडेंट. की हाईलाइट्स ऑफ द NCTD अमेंडमेंट एक्ट 2023 क्या है, द नेशनल कैपिटल सिविल सर्विस अथॉरिटी NCCA इट क्रिएट्स ए न्यू स्टैट्यूटरी अथॉरिटी NCCSA to make recommendations to Lieutenant Governor LG regarding transfer, posting, vigilance and other incidental matters. NCCSA shall be decided matters by the majority of voters of the member present and voting. The central government will appoint both the principal secretary and chief secretary. Power of the LG matters whether the LG may act solely or his discretion are matters outside the legislative competence of the Delhi Legislative Assembly but which has been delegated to Lieutenant Governor, or matters where he or she is required by law to act in his discretion or exercise any judicial or quasi-judicial function. Primacy to LG क्या है, तो it expand the discretionary role of LG by giving him power to approve the recommendation of the NCCSA or return them for reconsideration. The LG's decision will be final in case of difference of opinion between him and the authority. Disposal of matters by ministers. Certain matter must be submitted to the LGs by the ministers of Delhi government through the chief minister and the chief secretary for his or her opinion prior to the issue of any order. This includes proposal affecting क्या क्या है, तो द पीस एंड ट्रैंक्विलिटी ऑफ दिल्ली, रिलेशन बिटवीन द दिल्ली गवर्नमेंट एंड द सेंट्रल गवर्नमेंट, सुप्रीम कोर्ट और अदर स्टेट गवर्नमेंट्स, समनिंग, prorogation and dissolution of the legislative assembly, and matter on which LG is to give an order in his sole discretion. The governance model of Delhi NCT क्या है देख लेते हैं. Classification as a union territory UT under the States Reorganization Act of 1956. Delhi was classified as a UT governed under Article 239 of the Constitution. It states that UT are directly governed by the President or an administrator appointed by the President. Special status क्या था, तो following the recommendation of S. Balakrishnan Committee, the 69th Constitutional Amendment Act of 1991 conferred a special status of Delhi and designated it as a National Capital Territory of Delhi NCTD. It added Article 239AA to the Constitution and made Delhi a UT with a legislature and a council of ministers. The Lieutenant Governor LG is designated as the administrator of Delhi, operating with the aid and advice of the Council of Ministers of Delhi. Power of Delhi Legislature. The Delhi Legislative Assembly has the power to legislate over subjects in the state list and concurrent list, except for police, public order and land. Also, Parliament can legislate over all matters in the state and concurrent list related to Delhi. GNCTD Act, the Government of National Capital Territory of Delhi. GNCTD Act 1991 laid down the framework for the functioning of Delhi Assembly and the Delhi government. यहाँ पे देख लेते हैं कंपोजिशन ऑफ NCCSA. इसमें क्या, तो चीफ मिनिस्टर ऑफ दिल्ली एज चेयरपर्सन, Principal Home Secretary of the Delhi government as member secretary and Chief Secretary of Delhi government as a member. फिर एवोल्यूशन ऑफ एडमिनिस्ट्रेशन ऑफ दिल्ली गवर्नमेंट देखते हैं कैसे कैसे, तो 1951 में हुआ दिल्ली मेड ए पार्ट सी स्टेट. फिर 1952 में हुआ लेजिस्लेटिव असेंबली LA वाज क्रिएटेड विथ इलेक्टेड चीफ मिनिस्टर. 1956 में हुआ अंडर स्टेट रीऑर्गेनाइजेशन एक्ट दिल्ली बिकेम a UT. 1966 दिल्ली एडमिनिस्ट्रेशन एक्ट provided for a limited representative government in Delhi. फिर 1991 में हुआ 69th Constitutional Amendment Act and GNCTD Act 1991 passed. 2021 में GNCT Amendment Act 2021. Our next topic is preventive detention. Why in news? The Supreme Court, while setting aside a detention order, observed preventive detention law are a colonial legacy and they must be used only in rarest of the rare case. About preventive detention, तो क्या है? The preventive detention means detention of a person without trial and conviction by a court on a mere reasonable apprehension of him doing an activity dangerous to public order. Its purpose is to prevent the person from committing an offense in the near future. Protection against arrest and detention under Article 22, Clause 1 and Article 22, Clause 2 is not available to a person arrested or detained under Preventive Detention Law, Article 22, Clause 3. Parliament has exclusive authority to make a law of preventive detention for reasons connected with the defense, foreign affairs, and security of India. Both Parliament as well as state legislators can concurrently make a law for reasons connected with the security of a state, maintenance of public order, and maintenance of supply and services. Multiple laws such as Code of Criminal Procedure, Narcotic Drug and Psychotropic Substance Act (NDPS) 1985, Unlawful Activity Prevention Act (etc.) permit preventive detention. Constitutional provision related to preventive detention and judicial pronouncement related to preventive detention. तो पहले कॉन्स्टिट्यूशनल देख लेते हैं. Article 22, Clause 1. No person can be detained in custody without being informed of ground of arrest, nor shall be detained right to consult or be defended by legal practitioners. Article 22, Clause 2. Every person who is arrested, detained in custody shall be produced before magistrate within 24 hours of such an arrest. Article 22, Clause 3. Above two clauses will not apply to a person who is detained in accordance to a law providing for a preventive detention. Article 22, Clause 4. No person can be detained for more than a period of 3 months unless an advisory board confirms that there is sufficient cause for continuation of such detention. Article 22, Clause 7. A person can be preventive detained for more than 3 months without option of any advisory board if Parliament by law provide maximum period of such detention and circumstances, classes of person and classes of case to which such a law may apply. अब जुडिशियल प्रोनाउंसमेंट रिलेटेड टू प्रिवेंटिव डिटेंशन क्या क्या देख लेते हैं. तो ए के गोपालन वर्सेस स्टेट ऑफ मद्रास 1950, द कोर्ट गेव अ ग्रीन फ्लैग टू द प्रिवेंटिव डिटेंशन एक्ट 1953. अगला है सुबिनान लाल वर्सेस स्टेट ऑफ उत्तर प्रदेश 1954. सुप्रीम कोर्ट स्टेटेड दैट ए कोर्ट रूम इज नॉट competent to inquire into reality or in any case of the fact which are referended as ground of detention. Sambhunath Shankar versus State of West Bengal. Court held that sometimes state must take such extreme step to maintain the security of the country. अगला टॉपिक है पर्सनैलिटी राइट्स. न्यूज़ में क्या था? तो रिसेंटली दिल्ली हाई कोर्ट ग्रांटेड प्रोटेक्शन टू अ फेमस बॉलीवुड एक्टर्स पर्सनैलिटी राइट फ्रॉम मिसयूज बाय थर्ड पार्टीज. अबाउट पर्सनैलिटी राइट क्या है? तो पर्सनैलिटी राइट्स रिफर्स टू द राइट ऑफ अ पर्सन टू प्रोटेक्ट हिज और हर पर्सनैलिटी अंडर द राइट to privacy or property. It includes name, voice, signature, image, or any other feature easily identified as maker of personality. Personality rights in India. Personality rights or their protection are not expressly mentioned in any statute in India but are traced to fall under the right to privacy and the right to property. Two components of personality rights. Right to publicity. Right to keep one's image and likeness from being commercially exploited without permission. It is governed by statutes like the Trademark Act of 1999 and the Copyright Act of 1957. Right to privacy. Right to not have one's personality representative publicly without permission. It is broadly governed under Article 21 of the Constitution and the Supreme Court judgment in Justice K.S. Puttaswamy retired case 2018. Posthumous personality rights. Emblems and names prevention of improper use act 1950 protects unauthorized use of a few designatories name and symbol listed in its schedule. IPC. If negative reference or derogatory representation is made to any decreased person's reputation to or their family, a defamation suit can filed under the Indian Penal Code. Personality rights under International Convention. There is no explicit international convention or treaty on protection of the publicity right to date. However, certain publicity right can be derived from the following international conventions. Pala Rome Convention 1961. It protects performers' right, phonogram producers' right, and broadcasting rights. TRIPS Agreement 1994. It secured certain rights of the phonogram producer, live performer, and broadcast rights. WIPO Reference and Phonogram Treaty WPPT. It protects the right of performer and phonogram producer, particularly in digital environment. Constitutional provisions related to personality rights and judicial pronouncement related to personality rights. तो पहले कॉन्स्टिट्यूशनल देख लेते हैं. तो आर्टिकल 21 states that no person shall be deprived of his life or personal liberty except according to procedure established by law. आर्टिकल 300 में क्या है देख लेते हैं. 300A titled as right to property was introduced by 44th Amendment Act 1978 of the Constitution Act of India. It states that no person shall be deprived of his property save by the authority of law. फिर जुडिशियल प्रोनाउंसमेंट रिलेटेड टू पर्सनालिटी राइट्स क्या है. तो दीपा जय कुमार वर्सेस अल विजय केस 2019 मद्रास हाईकोर्ट held that personality rights cease to exist after the death of the personality and cannot be inherited by legal heir. Sakshi Malik versus Venkateshwara Creations Private Limited and ORS case. Bombay High Court held that using another's image and most especially a private image without consult is illegal. Our next topic is hate speech. तो ये न्यूज़ में क्यों आ गया. तो रिसेंटली द सुप्रीम कोर्ट स्टेटेड द नीड ऑफ स्टेक होल्डर टू फाइंड अ लॉन्ग टर्म सोल्यूशन टू द प्रॉब्लम ऑफ हेट स्पीच. अबाउट हेट स्पीच क्या है. तो हेट स्पीच हैव नॉट बीन डिफाइंड इन एनी लॉ इन इंडिया. However, hate speech generally refers to incitement to hately primarily against a group of person. Hate speech can be conveyed through any form of expression, including image, cartoons, memes, objects, gesture, and symbols, and it can be disseminated offline or online. Regulation of hate speech in India. Constitutional provision. क्या क्या है. तो hate speech can be curtailed under Article 19 Clause 2 on the ground of public order, incitement to offence and security of the state. भारतीय न्याय संहिता 2023 सेक्शन 196 Clause 1 penalizes promoting enmity between different group on ground of religion, race, place of birth, residence, language, etc. Section 299 defines punishment for deliberate and malicious act intended to outrage the religious feeling of any class. Section 235 Clause 1 and Clause 2 penalize the publication of circulation of any statement, rumor or report causing public mischief and enmity, hatred or ill will between classes. Representation of People Act 1951. Section 8 disqualifies a person from contesting an election if he is convicted for indulging in acts amounting to illegitimate use of freedom of speech and expression. Section 123 Clause 3A and Section 125 prohibit the promotion of enmity on the ground of religion, race, caste, community or language in connection with election as a corrupt electoral practices. Protection of Civil Rights Act 1955. Section 5 penalize incitement to any encouragement of untouchability through words either spoke or written or by sign, visual representation or otherwise. Religious Institution Prevention of Misuse Act 1988. Section 3 Clause G prohibits religious institution or their managers from using religious premises to promote disharmony or hatred among various religious groups. जुडिशियल प्रोनाउंसमेंट रिलेटेड टू हेट स्पीच में क्या क्या है, तो प्रवासी भलाई संगठन वर्सेस यूनियन ऑफ इंडिया 2014, द कोर्ट रिकॉग्नाइजेज द नेगेटिव impact of hate speech refer to matter to the Law Commission for in-depth examination. Shreya Singh versus Union of India 2015, Supreme Court held that responsible restriction under Article 19 Clause 2 on free speech and expression may be imposed only if it incited violence or lead to public disorder. Amish Devgan versus Union of India 2020, Supreme Court highlighted the need to balance the competing interest of free speech and prevent the spread of hatred and communal disharmony. अगला टॉपिक है प्लेसेस ऑफ वर्शिप एक्ट 1991. Why news? The Supreme Court observed that it cannot order a blanket stay on Worship Act. Please. About place of worship, a special provision Act 1991. The Act declares that the religious character of a place of worship shall continue to be the same as it was on August 15, 1947. It says no person shall convert any place of worship of any religious denomination into one of a different denomination or section. It also imposes a positive obligation on the state to maintain the religious character of every place of worship, and it existed at the time of independence. It declares that all suits, appeals, or any other proceeding regarding converting the character of a place of worship which are pending before any court of authority on 15th August 1947 bill abate as soon as the law comes into force. Exemption provided. तो कौन कौन सा था? The dispute site of Ayodhya is exempted from the Act. The Act also does not apply to monuments and sites covered by the Ancient Monument and Archaeological Sites and Remains Act of 1958. Any dispute that has been finally settled or disposed of, any conversion of any such place effected before such commemoration by executions. Penalty. Section 6 of the Act prescribed a punishment for a maximum of 3 year imprisonment along with a fine for contravening the provision of the Act. अगला है अदर इंपॉर्टेंट न्यूज़. तो कौन कौन सा न्यूज़ इंपॉर्टेंट था देख लेते हैं. तो 8th शेड्यूल ऑफ कॉन्स्टिट्यूशन. Odisha cabinet has proposed for the inclusion of Kui language in the 8th schedule. Schedule 8 of the Indian Constitution. It enlisted the official language of the country and consists of 22 languages currently. 14 languages were originally listed in the Constitution and the rest were added over time. Sindhi was introduced by the 21st Amendment Act of 1967. Konkani, Manipuri and Nepali by the 71st Amendment Act of 1992 and Sinthali, Dogri, Maithili and Bodo by the 92nd Amendment Act of 2023. Schedule 8 benefits. Support from government to develop recognition from Sahitya Academy and wider translation of its book can be used in assembly and parliamentary debate, can be used in all India competitive exam, RBI to include it in currency note denomination. 9th schedule of the Constitution. It was added to the Constitution by first Constitutional Amendment 1951 under Article 13(1)(v). Central and state laws included in 9th schedule cannot be challenged in court for validation of fundamental rights. However, Supreme Court in IR Koleo versus State of Tamil Nadu 2007 ruled that any law added to the 9th schedule after April 24, 1973 violating fundamental rights can be challenged if it undermined the basic structure as outlined in Article 21 along the Article 14 and 19. अगला टॉपिक था राइट टू साइलेंस. Supreme Court said that all accused have a right to silence and investigator cannot force them to speak up or admit guilty. Right to silence emanates from Article 20 Clause 3 which states that no one can be compelled to be a witness against himself. Protection is limited only to criminal proceedings. Right is not available to a person being interrogated interrogated under Custom Act 1962 or Foreign Exchange Management Act 1999. Such the person is not accused of an offense and isn't entitled to a lawyer. In Nandini Sethpati VPL Dani case, Supreme Court stated that competing a person to answer compelling a person to answer a question within the limit of police station may result in a violation of Article 20 Clause 3. Reservation for local in private sector. Punjab and Haryana Court quashed Haryana State Employment of Local Candidate Act 2020. Act provided 70% reservation to local in private sector jobs having monthly salary of less than 30,000 rupees. High Court declared it unconstitutional and violative of Part 3 Fundamental Rights of the Constitution of India. It also said that Act violates constitutional morality. Constitutional morality refers to adherence to the fundamental principle of the Constitution. It said state cannot discriminate against the individual on account of the fact that they do not belong to a certain state. Negative discrimination. Other states like Andhra Pradesh 2019 have also enacted similar act. अगला टॉपिक है affirmative action. Affirmative action means positive action या discrimination which was introduced in US to counter historical patterns of prejudice against individuals which contain identities, that is black, Hispanic and other minority student. Reservation is a system of affirmative action in India that provide historically disadvantaged group representation in education, employment, government schemes, scholarship and policies. Article 15 Clause 4 and Article 16 Clause 4 allow the government to provide for reservation. Reservation quota fixed at 50% Indira Savai judgment for OBC, SC and ST in both employment and education. Ranganath Mishra Commission. About Ranganath Mishra Commission क्या है तो it is officially known as National Commission for Religious and Linguistic Minorities. It was constituted to look into various issues related to linguistic and religious minorities in the country. Reports by Commission 2007 recommended that scheduled caste status be completely declined from religious and made religious neutral like STs. It has recommended permitting Dalits who converted into Islam and Christianity to avail scheduled caste status. Article 355. Article 355 is a part of emergency provision contained in Part 18 of the Constitution from Article 352 to 360. Article 355 says that it shall be the duty of Union to protect every state against external aggression and internal disturbance, and to ensure that government of every state is carried on in accordance with provision of this Constitution. Right to work. Punjab has become the first state to implement the right to work. Right to work make it mandatory for all road owning agencies, including the NHAI, to provide footpath and cycle track on the road. तो हमारा पहला सेक्शन खत्म हो गया. अब दूसरा सेक्शन शुरू होने वाला है. फंक्शनिंग ऑफ पार्लियामेंट, स्टेट लेजिस्लेटर एंड लोकल गवर्नमेंट. उसमें पहला टॉपिक है नो कॉन्फिडेंस मोशन. वाई इन न्यूज़, तो क्यों रहा न्यूज़ में? यूनियन गवर्नमेंट फेस्ड अ नो कॉन्फिडेंस मोशन इन द मॉनसून सेशन ऑफ द पार्लियामेंट. About no confidence motion, the no confidence motion, a legislative resolution introduced in the Lok Sabha that allows the opposition to challenge the government majority. If a no confidence motion is passed, the government of the day will have to resign. The motion of no confidence can only be moved in Lok Sabha. Constitutional article या rules of the business in Lok Sabha. Article 75 Clause 3, the constitution of ministers are collectively responsible to the Lok Sabha. Similarly, at the state level, Article 164 Clause 2 provided that Council of Ministers shall be collectively responsible to the State Legislative Assembly. Rule 198 of Rules of Procedure and Conduct of Business in Lok Sabha provides a provision regarding the motion of no confidence. Grounds क्या क्या है तो a motion of no confidence need not set out any ground on which it is based. Speeches, unless leave is granted by the House to move the motion, no speech is permitted in support of the motion. रिपीट मोशन क्या है? तो आफ्टर अ नो कॉन्फिडेंस मोशन हैज़ बीन डिस्कस्ड and negated by the House, another no confidence motion cannot be moved in the same session. यूजुअल प्रोसेस फॉर अ नो कॉन्फिडेंस मोशन, तो क्या क्या प्रोसेस है देखते हैं. पहला है हाउस एक्सप्रेसेस इट्स वांट ऑफ कॉन्फिडेंस इन द काउंसिल ऑफ मिनिस्टर. फिर स्पीकर एग्जामिन इफ द नो कॉन्फिडेंस मोशन इज इन ऑर्डर. देन द मेंबर हु हैज टेबल्ड द मोशन acts asks for leave of the House to move the motion. Next, Speaker then call upon members who are in favor of leave being granted. If not less than 50 member rises, the Speaker declare that leave is granted by the House. The motion is then taken up for discussion within 10 days from the date of the grant of leave. अगला टॉपिक है पार्लियामेंट्री प्रिविलेजेस ऑफ लैंड मेकर्स. तो न्यूज़ में क्यों रहा? तो रिसेंटली द सुप्रीम कोर्ट सेट अप अ 7 जज बेंच हेडेड बाय द चीफ जस्टिस ऑफ इंडिया फॉर रिकंसिडरेशन ऑफ इट्स 1998 जजमेंट इन द पीवी नरसिम्हा राव केस. मोर न्यूज़ में क्या है? तो पीवी नरसिम्हा राव केस जजमेंट केम इन द बैकड्रॉप ऑफ 1993 झारखंड मुक्ति मोर्चा बिरवरी केस. It upheld legal immunity granted to legislator against criminal prosecution on bribery charge for any speech or vote in Parliament as per Article 105 Clause 2 and 192 Clause 2 of the Constitution. About parliamentary privileges, it referred to legal immunity wherein legislators are granted protection against civil or criminal liability for certain action or statements made in course of their legislative duties. If an individual or authority undermines a parliamentary privilege of a member of the House, it is called the breach of privilege. Parliament till now has not made any special law to exhaustively codify all the privileges. Parliament is the sole authority to ascertain if there has been a breach or contempt of the House. No court is entrusted with this power. A member of House can raise a question involving a breach of privileges with the consent of the chairman or speaker. Privileges are based on 5 sources. तो कौन कौन सा सोर्स है? तो पहला कॉन्स्टिट्यूशनल प्रोविजंस. आर्टिकल 105 उसमें पावर्स एंड प्रिविलेज ऑफ बोथ हाउसेज ऑफ पार्लियामेंट एंड इट्स मेंबर एंड कमिटीज. आर्टिकल 194 पावर प्रिविलेजेस एंड इम्यूनिटीज ऑफ स्टेट लेजिस्लेटर एंड their members and committees. Article 105 Clause 2 no person shall be liable in respect of the publication of any report, paper, votes or proceeding by or under the authority of each house of the parliament. A similar provision exists for members of the legislature of the state under Article 192 Clause 2. Freedom of speech in Parliament. Article 105 Clause 2 states that no member is liable to any proceeding in any court for anything said or any vote given by him in Parliament or its committee. The freedom is subject to the provision of the Constitution. Example, Article 121 restricts the member from discussing judges' conduct and to the rules and procedures of the Parliament under Article 118. Article 122 restricts the court from inquiring into the validity of any proceeding of Parliament on the ground of alleged irregularity of the procedure, law made by Parliament. Freedom from arrest. Code of Civil Procedure 1908 provides legislator freedom from arrest in any civil case 40 days before and after the adjournment of the House and also during the session of the House. However, an MP doesn't enjoy any such immunity in a criminal case. Rules of both the House. Privileges based on rules of procedure and precedents. Parliament reserve the right to receive immediate information of the arrest, detention, conviction, imprisonment and release of a member on a criminal charge or for a criminal offense. Right to exclude strangers. House has the power to right to exclude a stranger from the proceedings. The right is essential for securing free and fair discussion in the House. अदर सोर्स में क्या है तो पार्लियामेंट्री कन्वेंशन एंड जुडिशियल इंटरप्रिटेशन। कंटेम्प्ट ऑफ हाउस में क्या आता है तो कंटेम्प्ट ऑफ हाउस इज डिफरेंट फ्रॉम breach of privileges. It is an act of omission which obstruct or has the tendency to obstruct either House of Parliament or its members, officers in the performance or their function. Parliament is the sole authority to ascertain if there has been a breach or contempt of the House. No court is entrusted with this power. House can commit an offender to custody or prison the contempt for a period limited to the duration of the House session. In case if an MP is found guilty, he can be suspended from the House or face expulsion. Rationale behind parliamentary privileges तो क्या क्या था तो ensure freedom of expression of the legislator without fear of legal consequences. Ensure attendance of the parliamentary session. Maintain the authority dignity of legislator. Carry out functions independently and effectively of both the houses without any interference. Parliamentary privileges क्या क्या है तो it is parliamentary standing committee present in both the House of Parliament. Consists of 15 members in Lok Sabha and 10 in case of Raj Sabha nominated by the Speaker, Chairman in case of Raj Sabha. Key function क्या तो investigate questions involving the breach of privileges of House or members are referred to it by presiding officer of houses. नेक्स्ट टॉपिक इज एक्सप्लोजन ऑफ लॉ मेकर। तो इसे हम अगले वीडियो लेक्चर में देखेंगे। इस वीडियो लेक्चर को यहीं पर समाप्त करते हैं। उम्मीद है कि आपको हमारा यह पहल अच्छा लगा होगा। अगर अच्छा लगा तो इसे ज़रूर देखें और ज़्यादा से ज़्यादा शेयर करें। या पूरा सीरीज़ चलने वाला तो इसे प्लेलिस्ट में जाकर ज़रूर देखें और इसका प्लेलिस्ट का लिंक मैं डिस्क्रिप्शन में डाल दूँगा तो उसे भी देखें। और इसके डिस्क्रिप्शन में बाजीराव एंड रवि की करंट अफेयर का भी पूरा कंपाइलेशन है तो उसे भी देखिए। उसका वीडियो हम लोगों ने बनाया हुआ है और वीडियो कंटिन्यू है उसका भी, तो उसे जरूर से जरूर देखें, इसे भी देखें। और अगर आप लोग हमारे चैनल पर नए हैं और अभी तक हमारे चैनल को सब्सक्राइब नहीं किया तो प्लीज़ इसे सब्सक्राइब करके हमेशा जुड़े रहें, क्योंकि बहुत सारा मटेरियल यूपीएससी का हम लोग देने वाले हैं जो आपको शायद ही कहीं एक जगह पर सारा मटेरियल मिल सके। तो बस हमारे साथ जुड़े रहें, आगे बढ़ते रहें और रिवाइज़ करते रहें, ज़्यादा ज़्यादा रिवाइज़ करें ताकि आपका एग्जाम अच्छा से अच्छा बीते। तो मिलता है आपसे अगले वीडियो लेक्चर में, तब तक के लिए जय हिंद जय भारत।